Good afternoon, members of the panel. My name is Austin Seah, and I'll be speaking on behalf of the respondent, the Games Disciplinary Committee, henceforth the GDC, on the first issue regarding GDC's quorum and a fourth issue on doping, which are Mr. Lander's issues on appeal for 14 minutes. My co-counsel, Mr. Brendan Zhang, will be speaking on issue 2 on the location of the tribunal and issue 3 on Ms. Tang's ability to participate in the qualifying games, addressing Ms. Tang's issue on appeal for 15 minutes. We respectfully reserve 1 minute for Sir rebuttal. Members of the panel, this case is not about sympathy for one athlete or the popularity of another. It is about upholding the rules of integrity of the qualifying games. The GDC acted within its mandate, applying the governing rules and principles to protect fair competition and ensure that the games are conducted without illegality or undue advantage. With that, I made 2 submissions addressing Mr. Lander's claims. Firstly, the GDC's quorum was not biased in coming to a decision, as both Ms. Farina and Mr. Douglas are independent and impartial arbitrators. Secondly, the GDC did not err in finding that Mr. Lander has been liable for doping. Blue Bat in its nature is a performance-enhancing drug. Turning to issue 1, while counsel for the appellant may seek to rely on Rule 33 of the CAS Code, this is wrong. If I could turn the panel's attention instead to para 37 of the record. What Mr. Lander intends to do is to challenge an arbitrator. To determine if an arbitrator should be challenged, the applicable rule should be Rule 34 from the CAS Code instead. Rule 34 states that, and I quote, "An arbitrator may be challenged if the circumstances give rise to legitimate doubts over his or her independence or over her or his impartiality." This threshold of legitimate doubt is similarly noted in Article 180 Part 1c of the Swedish Federal Act on Private International Law, which states that, and I quote, "An arbitrator may be challenged if circumstances exist to give rise to justifiable doubts as to his independence." Lastly, the threshold of justifiable doubt can be found in the exact same wording featured in the Malaysian Arbitration Act at Section 14.3 Part A, which states that the circumstances that give rise to justifiable doubts as to the arbitrator's impartiality or independence. This demonstrates that the evidence of biasness must be justifiable and concrete, and this threshold has been applied stringently in related cases. This high threshold of justifiable doubts has been illustrated in the 2020 Swiss Federal Tribunal case of Sanyang and World Anti-Doping Agency. The courts noted at paragraph 6.5 that there must be concrete facts objectively giving rise to the lack of independence. Turning to paragraph 4 of the record, Ms. Farina is described merely as Ms. Tang's cousin sister. While this indicates a blood relation, there is no evidence in the record that suggests any meaningful personal or emotional closeness between them. The absence of any indication of frequent interaction, shared household, or personal involvement beyond this genealogical link supports the inference that their relationship is more nominal than substantive. In disciplinary or adjudicative contexts such as the one we are presently faced with, a mere familial connection without concrete evidence of closeness does not, on its own, give rise to a reasonable apprehension of bias. Moreover, although the record in para 4 mentions that Ms. Farina had provided some on-the-side coaching, this should be viewed as a limited and informal engagement. There is no suggestion that she had a permanent coaching position or received remuneration, and such ad hoc or casual assistance, perhaps in the form of general sporting advice or occasional tips, does not amount to an entrenched professional association that will compromise impartiality. It is plausible that Ms. Farina's involvement was situational, incidental, and peripheral to Ms. Tang's competitive endeavors. Taken together, the tenuous familial link and the limited scope of professional contact point between a relationship that is neither close nor influential. There is therefore insufficient bias to conclude that Ms. Farina's role on the commission will be tainted by personal loyalty, dependence, or biasness towards Ms. Tang's. With regards to Mr. Douglas, the professional interactions such as the fan meetups as seen from para 26 of the record where both Mr. Douglas and Ms. Tangs were spotted together, are typical of public figures in an esports realm and do not indicate a privileged or adversarial relationship which would compromise his judicial capacity. The one-time special and personal sharing session, which the appellant seeks to rely on, was an event that took place 6 months prior to the tournament, as seen from para 26 of the record. A single historical event, even if it led to them remaining in contact since, does not establish an ongoing, dependent relationship that will necessarily sway his judgment regarding the complex legal issues of doping and eligibility. Secondly, even if there was a finding of relationship, there must be ongoing economic ties or ties that have ended recently to demonstrate a lack of independence or impartiality. This was noted in a 2015 case of AVB, heard in the Federal Supreme Court of Switzerland. In our case, there's no economic ties between Ms. Farina and Ms. Tangs, as they are merely distant family members, in which Ms. Farina only acted in the capacity of a coach, as I mentioned before. Noting that Mr. Lander is the one alleging the presence of a lack of independence, the burden of proof would be on him. With respect to Mr. Douglas, there's only a coaching relationship, as well as seen from para 26 of the record. While their relationship got closer, there's still no evidence of any economic ties of which Mr. Douglas would have had a profit in ruling in favour of Ms. Tangs. Therefore, the GDC submits that its quorum was not biased in coming to a decision, and hence its decisions should be upheld. Turning now to the second issue, we submit that the GDC did not err in law. Our submission are structured into two main arguments. Firstly, the GDC acted within its jurisdiction in finding that Mr. Landert committed a doping violation under Rule 12 of the qualifying game rules, hereinafter the QGR. Secondly, the GDC's decision was consistent with CARE's jurisprudence and Lex Portavia principles. Turning to our first argument, the GDC had acted within its jurisdiction and discretion under the QGR, and Mr. Landert hence breached Rule 12 of the QGR. To provide clarity to the panel, I'll read Rule 12 in its full. I quote, "It defines a prohibited substance as any substance or method contrary to the spirit of the sport. This clause grants GDC residual discretion to protect sporting integrity even for unlisted or newly discovered substances." I note the issue of the definition of the spirit of the sport, and this has been addressed in the WADA code at page 13, which reads, and I quote, "The spirit of the sport is a celebration of the human spirit, body, and mind. It is the essence of Olympism, and is reflected in the values we find in and through sport, including the value of excellence in performance." Putting this in context of Quidot, it is essentially an e-sport where concentration and focus is the key to winning. This is something that Mr. Landert knows very well, with himself coming in clutch in draw-breaking games, as seen from para 6 of the record. As seen at para 12 of the record, the final match between himself and Ms. Tangs, such a close game is extremely close and extremely tiring on the eyes and mind. Therefore, the player who deserves to win is one who is able to, without any doping or assistance, focus all the way to the end. However, Mr. Landert was only able to win with the assistance of Bluebird. Crucially, if I could first turn the panel's attention to para 12 of the record, Mr. Landert, knowing that Bluebird could keep his energy up, kept them nearby. Ms. Tangs, with her dominant performance as seen from para 11 of the record, was bound to have won the tournament, if not for Mr. Landert's intervention with 5 points. This concentration-enhancing drug essentially allowed Mr. Landert to take the edge over Ms. Tangs, as seen at para 13 of the record. Therefore, his actions go against the core of rewarding a player's excellence in performance, which is against the spirit of the sport. Rule 12 of the QGR further instructs athletes to refer to the WADA prohibited list, but the term signifies guidance rather than exclusion. It does not explicitly state that Rule 13 will override Rule 12 in any way, shape, or form. Therefore, the Commission's reliance on Rule 12 was appropriate, and the GDC's decision to sanction Mr. Landert for conduct contrary to the spirit was within its jurisdiction and consistent with its mandate to protect fair competition. Secondly, the GDC's decision was consistent with CAS jurisprudence and Lex Bodivia principles. In the 2004 CAS case of Maria Louis Kelly Williams and IOC, the tribunal accepted that an unlisted substance could still fall within the scope if it exhibited similar pharmacological effects or violated the spirit of sport. Professor Caitlin's expert report, cited on page 3 of the judgment, concluded that although not expressly listed, the substance, isomethapine, had a similar pharmacological effect to other prohibited stimulants under Article 4 of the IOC rules. The panel accepted that anti-doping authorities could act on such evidence to preserve fairness. Analogously, Bluebet enhanced concentration and alertness in competition, mirroring the very harms that anti-doping rules aims to prevent. Crucially, this approach is further reinforced in the 2005 US and Belco case, where the performance-enhancing drugs was addressed. In an investigation against Darwin Chambers, the arbitrator observed and I quote, "It will be impracticable to find all forms of steroids in a list of prohibited substance, and that restricting prohibition to certain named substance would be both unfair and detrimental to sport." This reasoning directly supports the GDC's proactive stance by developing Rule 12 to function as a catch-all clause. Applying these principles, the GDC's decision was reasonable and proportionate. Bluebet, while not on the WADA prohibited list, demonstrably enhanced cognitive focus and stamina, creating an unfair advantage. Accordingly, with the application of Rule 12 of the qualifying game rules, the GDC did not err in finding that Mr. Landert had committed a doping violation. In conclusion, in response to Mr. Landert's issues on appeal, the GDC maintains that the quorum was not biased, and the GDC was correct in finding that Mr. Landert committed a doping violation. Unless I may be of further assistance to the panel, this concludes my submissions. Thank you. I'll now hand over my time to my co-counsel, Mr. Brandon Zhang, who will address the remaining two issues.